May it please the Court, I appear for the Secretary of State, along with Mr Grant. My learned friend Mr Edwards of King's Counsel appears for the Respondents alongside Mr Rhymes. The Court should have a core bundle which has 26 tabs, which include, in and amongst them, the replacement skeleton arguments. There should also be a supplementary bundle that runs to 15 tabs, and an authorities bundle with 10 tabs.
Yes.
If it's convenient to the Court, I intend to structure my submissions and opening in 6 parts. First, an introduction, which I'll keep as brief as I can, to the issue for the Court. Second, the key facts.
Yes.
Third, the key components of the statutory scheme. Fourth, the key authorities. And I'll try and take those in some ways as briefly as I can for reasons I'll explain when I get there. Fifth, submissions on the key paragraphs of the inspector's decision, the planning inspector's decision in light of those authorities. And then sixth and finally, submissions on why, with respect to the judge below, her approach was incorrect.
Yes.
So turning first then...
Well, just before you get going, just to help you, we are, of course, familiar with the materials which you've referred to.
Yes.
You can take it that we have read with care the salient parts of the material, including, of course, the decision letter.
I'm grateful.
And, of course, the skeleton arguments on either side. And we are reasonably familiar with the authorities, to which no doubt you're going to refer when you come to your fourth part.
Yes.
So if that helps you, and the other side as well,
I'm grateful.
We shall be glad.
I'm grateful, my lord, and I'd anticipated certainly when it comes to the Kestrel case, which is on either side's approach central to the issues, given that of course it was your lordship's judgment. I was intending to take certainly the other authorities. The first instance case is a bit shorter than I would otherwise have done, because many of them are touched on or summarised within Kestrel itself. But I'll come back to that.
Yes, indeed. All right.
So turning to the first of my 6, to introduce the issue, the question in this appeal is, we say, that the same question, actually, as that identified by my Lord the Senior President at the first paragraph of Kestrel. The question is, in what circumstances can an enforcement notice issued by a local planning authority against an unlawful change of use require the removal of a building connected with that use? And to unpack that question, I'll make 4 short introductory points before turning to the facts. First, I'll touch on the key features of the statutory scheme, just by way of headline overview. Secondly, I'll briefly introduce the so-called Murphy principle and touch on why it fits into and is an expression of that scheme.
Yeah.
Third, I'll mention that the key mischief the Murphy principle was intended to avoid, which is to say the absurdity of useless development. And finally, in introduction, I'll explain the putative addition to the Murphy principle, which was identified by the judge below, and indicate, just again in headline overview, what the key error in her approach was. Right. So first then, the most important features of the statutory scheme, which I'll obviously develop under later on in more detail, but just to set out the headlines, the English planning system is from the start, which is to say from the Town and Country Planning Act 1947, always done and still does the following 5 things. First, it requires that planning permission be granted for development. Second, it defines development to include at least 2 different things: operational development, which can include building works and engineering operations, and also making any material change in the use of any buildings or other land. Third, it allows local planning authorities to issue enforcement notices if development, as defined, occurs without planning permission. Fourth, it allows such enforcement notices to require steps to be taken for restoring the land to its condition before the development took place. That was in section 23 of the original Act in 1947. It's now in section 173 of the 1990 Act. I refer to this later as the restorative power for shorthand. In my Lord, the Senior President's judgment in Kestrel, it was referred to as the remedial power, but it's the same thing. Fifth, the statutory scheme specifies that steps in the enforcement notice for those purposes may include a requirement to demolish buildings. Again, section 23 of the original Act, and it's now again in section 173 of the current Act, to which I will take the court soon. Now, the second of the four short introductory points is just to touch on the role that the so-called Murfitt principle plays in all of that.
Yes.
It will often be the case that acts of development only involve one part of the multi-part definition. So, for instance, doing building works will often not bring about any material change of use of land if you were, for example, rebuilding or extending a house on land that's already used for a house or for houses. That kind of development would be, or could be, only, in inverted commas, operational development. Equally, materially changing the use of land will often not give rise to the need for any building works. So, for example, changing the use of a house to a shop or to an office without the need for any external renovations. That kind of development would be, or could be, in inverted commas, simply a material change of use. But there are other cases when building works involve a change of use, or when a change of use involves building works. And in those cases, the courts have held for some 44 years now, since Murfitt in the Divisional Court, that enforcement notices against unlawful changes of use can require the removal of buildings too, so long as they are integral to or part and parcel of the change of use. Those are phrases which emerged from the submissions of Simon Brown as he was then acting for the Secretary of State in the Murfitt case.
Also ancillary, I think.
Yes, we'll come back to ancillary, that's right. This principle, known in some of the cases as the Murfitt principle, withstood a head-on challenge in this court in the Kestrel Hydro case in 2016. It emerged intact through the lead judgment of my Lord the Senior President. A judgment, obviously, which I'll come back to, but a judgment which endorsed Murfitt as good law, which confirmed that its application is a matter of fact and degree for the decision maker in each case, and confirmed that the Murfitt principle does not cut across the statutory regime. On the contrary, it is an expression of that regime. In particular, when there's enforcement against an unlawful material change of use, the Act provides this restorative power. It allows an enforcement notice to specify steps to be taken for the purpose of remedying the breach, which can include, as I've said, restoring the land to its condition before the breach took place. Now, the Respondent's case in this court does not purport to depart from Murfitt, as the unsuccessful appellant did in the Kestrel Hydro case. But it is telling how many of their arguments that Murfitt should not be, quote, overstated, echo the unsuccessful arguments from the appellant in Kestrel Hydro that Murfitt should not be followed at all. And I will return to this later. Third of 4 points in introduction, I just touched on the key mischief that the Murfitt principle was intended to address. The prospect of enforcing against an unlawful change of use, but not requiring steps to restore the land to its previous physical condition, risks what Mr Justice Stephen Brown, as he was then, he described it in Murfitt as making a nonsense of planning control. Again, that restorative power has always been at the heart of this legislative scheme over the 77 years since the 1947 Act, and that's for good reason. The restorative power in the Act avoids the risk of absurdity. The absurdity would be where you've got an uncontested finding of an unlawful material change of use which can be enforced against, which happened in this case, as I'll show you, but that building works which are fundamental to that change of use remain intact, incapable of being enforced against in perpetuity. A ghost building, immune from enforcement, but with no lawful use at all. Particularly, as I'll develop in a moment, in the context of a greenbelt site like this one, where national policy presumes against new built form, the prospect of a building which was never built for any lawful use and cannot, without some sort of further step, be turned to any lawful use, remaining in situ, in perpetuity, which is the effect of the judge's findings below, risks making the sort of nonsense of planning control that was described in the Murphy case. And it's to avoid that sort of nonsense, insofar as it can be avoided, that the legislative scheme recognises, and has always recognised, this restorative power, the ability of enforcement notices to remedy material changes of use, not only by requiring them to cease, which obviously they can do, but also by requiring steps to be taken, steps so that land is restored to its previous condition, including, where appropriate, by the removal of buildings which are, to summarise Murphy, integral, although also part and parcel of ancillary to the change of use. Fourth, and finally, by way of these introductory remarks, I'll just touch briefly on what went wrong in the judge's approach below. On the facts of this case, to which I'll take the court shortly, a planning inspector was taken with the assistance of legal submissions from Council to Murfitt, to Kestrel, and indeed to several other of the authorities. As I'll show the court, the inspector's analysis of and understanding of those authorities was impeccable. His application of the principles in those authorities to the facts before him was open to him as a matter of judgment and degree, informed as it was by written submissions, statutory declarations, proofs of evidence, oral evidence, including cross-examination under oath, and indeed a formal site visit. The judge below quashed the planning inspector's decision on the basis that the inspector had failed to acknowledge what she held to be a further principle. The putative principle is spelled out in particular at 39 of her judgment, and I'll take the court there later, but it is, in short, that the test in Murfitt will be failed where buildings are themselves the source of or fundamental to, as she put it, a change of use. The judge's putative principle rests on what she thought was a distinction between building works which are integral to a change of use, and so can fall within the Murfitt principle, and building works which are fundamental to a change of use, and so which she thought cannot fall within the Murfitt principle. And with respect to the judge, and for reasons I will obviously develop later, this is wrong. And to just give you very short reasons now as to why. Firstly, the judge did not analyse what my Lord the Senior President described in Kestrel as a central concept in this part of the statutory scheme, which is to define those matters which actually constitute the breach of planning control in the first place. The judge's putative principle is not legally coherent, obviously I'll develop this later, but a distinction between buildings which are integral to a change of use from those which are fundamental is not, with respect to the judge, a coherent distinction of principle. Nor is it an approach which accounts for the fact patterns in the cases. For example, the hard standing in Murfitt, which we'll come back to, was fundamental to the change of use that occurred there, literally and figuratively too. The judge also says that building works fall outside the scope of Murfitt if they are the source of a change of use, or causative, another way she put it, of that change. And that approach too, with the greatest of respect to her, is not legally coherent. The so-called source of a change of use is not a building, it's the change of use. actual or prospective. Similarly, what causes, the other way she put it, a change of use is not operational development. Changes of use are caused when uses change or when they are soon to change. And again, I'll develop that later. In reality, the judge's supposed principle in her judgment, in particular at 39 where she draws it together, trespasses into matters of fact and degree in relation to how the principal act of development is to be defined.
I'm sorry, I don't quite follow that last submission at all. It must be my fault, but a change of use is a change of use. It cannot be the cause of a change of use. It can't be the same thing as what causes it.
The cause of a change of use is the actual or prospective use itself. It's when people, or start using or are soon to start using. This is looked into in a little bit more detail in Hatfield in the Supreme Court, which I'll take your ladyship to shortly. But it's not operational development. Operational development does not cause a change of use. There are certainly cases where it might be a necessary, precondition for a use to change, but it's not causative of, because the use changes when it changes. The judge casts what appears to be a disagreement that she has with the planning inspector on the facts of this case in the language of a legal principle. She appears to have thought, on the facts, that this was a case where there was a, quote, principal development, and that principal development was the building of a house, which she thought gives rise to a change of use. Now, that was her view. But that was not how the inspector analysed the facts of this case. He found, and I'll show the court shortly where he does this, that the principal form of development was a change of use, as a matter of fact and degree for reasons that he explains, and the construction of different buildings, including the house, was associated with that principal development. Now, remember, of course, the judge does not find that that's irrational. She doesn't, for reasons she explains, go into whether it was a rational approach or not. She leaves that open. Instead, what she does is attempt to cast or recast the principles in Murfitt, and indeed in Kestrel, so as to intrude into what was a core finding of the inspector's planning judgment, which is to say, what is the principal development in this case? And by trespassing in this way into what are in the end matters of fact and degree, without any finding that the decision was irrational, the judge's approach is inconsistent with Murfitt, and certainly Murfitt has explained in Kestrel Hydro, where my Lord the Senior President made absolutely clear that applying this principle to the facts of a given case involves a series of matters of judgment on questions of fact and degree.
Does this argument mean that if I put up a house, as it were, more than 4 years ago, given the time limit in the statutory scheme, and then use it as a house, then that constitutes a material change of use of the land, that the house then is not subject to the 4-year rule, because it's somehow, I'll use different language, associated with the use, and that has the effect of avoiding the differential time limits for enforcement in the Act. Is that what the argument means? Whenever I put up a house and then start to use it as a residence, so residential use, does the argument effectively say that whenever that happens, the 4-year rule doesn't bite?
No, the argument does not extend that far, because of my Lord's use of the term whenever. I don't go that far.
Well, I think we do need to know at some point, not necessarily straight away, but at some point we need to know quite where the argument does go, what its implications and consequences actually are.
Yes, of course, my Lord.
Because a central part of the argument you face from the other side is that the effect of your argument really is to to override or indeed distort the statutory scheme. In
Absolutely.
That way.
And so I appreciate
that you will need to confront.
that. I will need to confront, and so the onus is on me to explain how my submission fits into, as I say, it does, the statutory scheme. It doesn't seek to cut across it. And the short answer that I will develop is that the starting point for all of this, and this will be different case by case, because it'll always be a question of fact and degree, depending on the case. The starting point is to identify what the breach actually is, what the relevant breach is. That's step one. Step one in the statutory scheme, as I'm going to show the court shortly. And there is not necessarily a legally correct answer, if you like, in the sense that it may be a matter on which rational decision makers might take different views on the matters of, on facts and degree in different cases.
If you're right about that, then the application of the statute is very nebulous, because one planning inspector will say, well, the breach is changing the use of the land, and another planning inspector will say the breach is operational development.
Well, I'd certainly accept that it would be theoretically possible for two decision makers, two inspectors, to come along and look at a site or a scheme or a change of use or whatever and take rational but different views on those questions. But of course the same is so when it comes to dealing with the Murphy principle in general, because these issues about whether or not a building is integral to or part and parcel of or whatever a material change of use, there's no, the statute does not prescribe an answer to that question. It is to take my lady's term, nebulous, in as much as it will require the exercise of planning judgment in every case, and it may be, as I say, that different decision makers take.
There's a world of difference between saying you can characterise the breach in one of two different ways and saying that on a particular development you can ask yourself a question: is this particular operational development ancillary to the change of use? To use my Lord's terminology, that will be a question of fact and degree as to whether it's ancillary, but at least you've got something for it to be ancillary to.
Yes. No, I appreciate that, my lady. I as I say, and I won't. I'll develop later quite why, to take my lady's term, that the term nebulous. If nebulous is synonymous to, well, there's a series of judgments here, and it may be that different decision makers come at it from and reach different views on the facts of a given case. I can't dissent from that.
Well, what I'm getting at, Mr. Simon,
Yes.
so that you actually have a chance to grapple with it, is that it creates uncertainty in the planning regime.
To the extent that there is uncertainty in the regime, it's there already, as for reasons I'll develop. It's there as a necessary function of the way that the statutory framework is set up now and has been set up since the original Act in 1947. And I think the courts, since Murphy, have been trying in some ways to address some of that uncertainty. And in some ways, this case is the next step in that exercise that began with Murphy and culminated in Kestrel in 2016. I do not dissent from the proposition that there is uncertainty in advance, if you like, before one addresses the particulars of a given case as to how a decision maker may or may not fall on that case. But if that sort of uncertainty, my lady, is not, for better or perhaps for worse, it's not unfamiliar to many corners of the planning system, because so many of these judgments for planning inspectors in particular are in the end turn on matters for their own evaluative decision making. The laws there obviously set the parameters within which those decisions can be taken, but they're far from it far from predetermines the outcome. That was all I was intending to say by way of introduction. Turning to the facts, just to introduce, and the court will hurry me along if this is unnecessary. The site itself can be seen if the court takes up the supplementary bundle and turns in it to tab 7, page 69. To use it's the pagination on mine in the bottom right-hand corner. There's a figure 12, which is a photograph of the.
Sorry, give me the page again.
I'm sorry, my lord. It's page 69, bottom right hand corner. And hopefully the court. Hopefully you've got a colour copy, or else it won't be easy to follow. But
Very small aerial photograph.
yeah, it's very small. It's just to give the court a broad idea. This is the best I could find in the papers. The site is marked, although it's a very, very small dot, in red, immediately to the south of the A40, which is also known as the London Road, to the east of Beaconsfield in Buckinghamshire. The site falls entirely within the metropolitan green belt, where, as the court's aware, national policy presumes against what's known as inappropriate development, defined as to include most kinds of new building, and also material changes of use that harm the openness of land, unless very special circumstances exist. We see the site in a little bit more detail, zoomed in over the page on page 70. And the court should see a tarmac strip running east-west through the site, which is a historic section of the A40 that was realigned in the 1970s. We see Pyebush Lane running sort of broadly north-south or north-east, south-west on the western boundary of the site. And obviously we see the A40 itself immediately to the north of the site.
Is Pyebush Lane a cul-de-sac?
Yes, it is. That's correct.
I mean, it goes underneath the motorway.
Yes, that's
and then seems to peter out.
Yes. Just so the court has an appreciation as to how the site is viewed, if you like, on the ground, we see from all four angles. From page 71, we see the site viewed from the main road, from the A40.
I said the motorway. I shouldn't have done it.
Yes, no, the motor. We're not far off. The motor, the M40 is
the
south dual carriageway. Yes. So we see the site from the dual carriageway on 71. We see the site from its main access on Pyebush Lane on page 72. We see the site from there.
And so on page 72,
yes,
that which we're looking at was the A40.
That's right. That's correct, my lord.
So that's not new.
No. Although the gate is
So
relatively
they've
new.
had 3 goes at this road. That was the A40, now there's the A40, and now there's the M40.
The M40, yes. That's right, my lord. That's right. So that's page 72 from Pyebush Lane. Page 73 is from the south. A public footpath runs along the south, and indeed from the east we've got page 74. And indeed also from these page 75, which is another viewpoint to the east of the site. The respondents, planning consultants in this document on the top of page 76 noted that the site is largely screened from most public viewpoints, and obviously the court can readily appreciate why that was correct. Now, a number of buildings and structures are within this site. Several plans showing them in slightly different locations are in the papers. Just for ease, I'll use the planning inspector's plan, which was the final word, if you like, on all of this. And that plan is in the core bundle, right at the end, final page.
Page 255.
Page 255. This is the plan, what became the enforcement notice plan, but I'm just using it to illustrate what was there and where it was in from the inspector's point of view. Five structures, all labelled, and including, of course, as building A, the goose house. That's what's there. Chicken coop, feed store, utility building, and a storage building.
Is it a tiny detail? Is the building called the Goose House or simply Goose House?
I've seen it referred to in both ways.
Yeah, that's why. I think that's why I asked.
I think the goose house is what we're going for.
The Goose House.
The goose house. So yes, it may be I slip.
Refer to it with the.
The goose house.
The Goose House. Right.
I'm grateful.
Thank you.
And the goose house is photographed back in the supplementary bundle, just so the court can see what the structure is that we are talking about. It's in the same tab that we left off in the supplementary bundle, tab 7, page 46.
Thank you. Yeah.
Now, the key points of chronology I'll take shortly, but just to give the court some of the key dates. They're set out most conveniently at tab 15 of the supplementary bundle, which falls into a proof of evidence provided to the inspector on behalf of the local planning authority. And the chronology, I'll start, if I can, at page 139, again, bottom right-hand pagination. Hopefully the court, if the court's got 139, there's a heading introduction.
Is this is
I'm sorry.
an additional document, is it?
Yes, it was additional. It was sent through to the court.
Yes, for some reason it hasn't caught up with me.
This is the supplemental bundle.
This is supplementary bundle, tab 15. If not, we've got copies of it.
This was an additional.
It was an additional document that was erroneously
I
excluded.
don't know if my colleagues have it.
Yes. Check.
It hasn't reached
Does
me.
my lady have
I've
it?
got it, yes, thank you.
Does my Lord Coulson have
I
it?
do.
Tab 15.
I do, thanks to the efforts by my Lord's various assistants. So I'm feeling guilty now that I've got it.
I'm very grateful. We
my
do
Lord
have a
doesn't.
spare. Perhaps I could hand.
Do
Shall I
you have
hand
a
a spare up?
Don't worry. Do you have a spare copy?
We do have a spare of just. I think we really need the one spare by the look of it.
Well, I think
Which
Which
is
there's,
only-
is it? There's a spare one there.
there's one sitting on the.
Oh,
Bench.
no, it's a spare there. It should. The first page of it is.
No, it's sitting. It was sitting on the bench here.
Oh, right. It should start at bottom right-hand corner, pagination 135 is the first page of it.
Yeah, that's
Okay,
right.
great.
We got it too.
Yes.
Yes, no, we've all got it.
I'm grateful. So at page 139, again, bottom right-hand corner,
Yeah.
hopefully the court has the heading in introduction. And it's just to note that some of this terminology gets used repeatedly through the paper. So 1.2, there's a reference to the Goose House, freeze of reference. The Goose House is referred to as Appeal Site 1. So when we see references to Appeal Site 1, we're talking about the Goose House area.
Yeah.
And then at over the page on 140, there's a reference to 1.7. There's a reference to land to the east of Pyebush Lane. It lies south of the Goose House, north of Minstrel's Mead, on physically separated and enclosed parcel of land. And this is something different, not directly in play before the court, but this is called Appeal Site 2, just to make sense of what follows. Now, the chronology of events begins on page 149. Towards the bottom of that page, heading chronology. We see at page 150, 4.3, that over many years there were attempts to secure planning permission to build a dwelling house for the SAP, an appeal site, to which were unsuccessful for reasons that related to the green belt. Over the page at 4.9, we see that in 2011, a lawful development certificate was obtained for an existing electric gate and 2 metre high closed board fence surrounding Appeal Site 1, which the court's already seen photographs of. At 4.11, we see that in January of 2014, the council received a complaint reporting the construction of the Goose House, which was alleged to have begun in November of 2013. An enforcement officer visited and photographs were taken. And then we see at 4.12 a bit more information about this period of mid-2013 to mid-2014. The appellant's evidence was now the respondent's evidence is that there was the construction of the Goose House began in November of 2013 and was substantially completed at the end of March 14 and indeed was moved into during May of 2014. That was the respondent's case. At 4.16, in July of 2018, enforcement officers attempted to inspect but couldn't speak to anyone or gain entry. In 4.17, in December of that year, a planning contravention notice was issued, to which there was no reply. In September of, over the page, at 4.18, in September of 2019, the enforcement team attached something called a notice of entry onto the land, confirming that they were going to come back on the 19th of September. And in the next paragraph, 4.19, we see that on that date, officers attempted to get in but couldn't. They noticed that the top of the gate and fencing had a fresh application of a tar-like substance believed to be anti-climb paint. At 4.20, there were 3 further attempts to engage with the then appellant, but were all unsuccessful. At 4.21, in November of that year, there was a further planning contravention notice, which included both appeal sites, 1 and appeal site 2, to which there was a reply on the 6th of December of 2019 from Mr. Caldwell's agent, and it summarises what the agent said in the bullet points.
Do we have an explanation anywhere from the council of their reasons for not having issued an enforcement notice sooner than they did?
I don't believe that we do.
Is that a matter of any discussion or evidence at the inquiry?
Not that I've seen, and not particularly that question as to why this chronology is as it is, and why they didn't go sooner to. I'm obviously coming to where they do issue an enforcement notice, which is on the next page.
On the face of it, they were alerted to the construction of the Goose House as long ago as January 2014.
That's right.
Paragraph 411.
That's right. And that's right. I've got
And it was substantially complete at the end of March 2014.
That's right.
To this, and there was no relevant event between March 2014 and March 2018.
Correct. Correct. By relevant event, if
I mean, there was no
there was no
according to
notice,
this.
or...
I mean, there might have been some construction of the ancillary dwellings, or ancillary buildings, but there was no action by the council between March 2014 and March 2018.
I believe that. Yes, that's my understanding of the chronology.
Yeah.
And they're not here to.
They're not here to help.
They're not here to help the court.
No, they're not.
Lest that be misunderstood, that they are not taking any part in the proceedings, and therefore we are not in a position to ask them to help us.
Yes, my lord.
Let to be absolutely clear.
Well, so over the page, on page 154, 4.22, is a reference to a February 2021 report stating that an officer had visited the sites, confirmed ongoing residential use of the Goose House. And then we get to the enforcement notice at 4.23, which is issued 23rd of February 2021. Now, we have the enforcement notice in the supplementary bundle at tab 4. The court could go there.
Thank you.
Starts on page 12. The enforcement notice, and it's self-explanatory, but in the first numbered paragraph of it identifies what appears to be to the council a breach of planning control under section 171 capital A 1A of the Act, and I'll show the court what that section says in a few minutes. And they consider that it's expedient to issue the notice. 2 identifies the land to which the notice relates and incorporates a plan, which is a few pages on page 15. 3, which is critical on my case, because 3 is something that ended up being a matter of some debate before the inspector and was ultimately resolved in favour of the council at the inquiry. 3 is the section where the council identifies the breach of planning control alleged. And that breach is, without planning permission, the material change of the use of land and the carrying out of operational development to facilitate the aforesaid unauthorised material change of use, including the things that are set out there. So you come back to how that was resolved before the inspector, but that was the fundamental breach that was alleged. 4 sets out the reasons that for issuing the notice, and goes into the points about the site's greenbelt location, etc., and the need to demonstrate very special circumstances. And 5 obviously sets out the requirements of what the notice sought to achieve. So the first of which was to cease the use, and then there were other things too, including the demolition and dismantling of buildings. Now, the Respondents appealed against that enforcement notice to the Secretary of State under Section 174 of the 1990 Act that I'll show the court shortly. The appeal was determined at a planning inquiry before a planning inspector. Both sides put in evidence, written and oral. The appeal was run on 5 grounds. I'll show the court shortly what those grounds are in the statute. Those grounds included that the breach had not occurred at all. It included that the planning permission should be granted for the state of play on the ground. It included an allegation that the steps required in the notice are excessive. And also, it included an allegation that by the time the enforcement notice was issued, it was too late to take enforcement action. It's known as a Ground D appeal, and again I'll show the court what those grounds look like.
So that's ground D.
That's Ground D, exactly. 5 grounds were run, of which Ground D was 1. Now, the council's evidence, I've actually taken the court to some of the council's evidence already in writing. That's again at this tab 15, the late document in the supplementary bundle. Notes from, if the court could just very briefly turn back to that document, tab 15 in the supplementary bundle. On page 146, there's a series of site observations in the run-up to the appeal being determined. Uh, 3.1.4 and following describes the site visit that was undertaken by the council in the run-up to the inquiry, the post-enforcement notice. Describes the previous difficulties gaining entry, the boundary fences, the anti-climb paint, number of security cameras and features that, so the council's officer said, made it sound like something of a fortress. Over the page at 147, at 3.1.5, the reference to no clear views, to views being obscured by high fences and gates, some with spiked edges, mature trees, etc. And at 3.1.6, references to barbed wire, to CCTV cameras mounted on the fence with the electric gate.
Just pausing, I think this is uncontentious. This is not what is sometimes referred to as a concealment case.
No, it's not. It wasn't put in that way by the council. I'll show you what they did say about it, but it's not a concealment case. They did allege that the breach of planning control was intentional, but they did not allege that it had been deliberately concealed.
Well, they couldn't because they knew about it.
Yeah.
They knew about it in January 2014. So, unlike in Hatfield, for example, I mean, this isn't one of those cases where 4 years to the day after the event, the curtains are rolled back and something that's been there all along is revealed. They knew about it whilst it was being built. That in January 2014
is true, although it would also be, and it's not. It has not been put in the same way by the local authority as the Welwyn case, as my lord says. On the other hand, the first time after some trying that the local authority received a response to its planning contravention notices, which are notices that set out a series of questions to establish what the facts are that precede enforcement. First time was in December of 2019, outside a 4-year period for from when the
notices were themselves outside the 4-year period.
The notices were, well, some of them
established that the council hadn't taken any steps between March 2014 and March 2018.
That's right.
If we take 4 years starting at substantial completion, with my construction hat on, that would probably be right. You add 4 years, so you get to the end of March 2018.
That's right, my lord.
So that's the relevant period.
No, that's absolutely, that's quite so.
The short answer to my lord's question is no, this is not. This has never been put as a concealment case.
That's absolutely right. It's never been put as a deliberate concealment case like the Welwyn scenario. The council's case, I'll just quickly note because it's relevant to what my lord's just said. Page 158 of this evidence that the council have put in. At 5.10, it it is noted, just on my Lord's question about dates, that council officers did attempt site visits in at least 4 different calendar years. It doesn't tell us what months those you know, within which month those visits were attempted. But some of that tallies with the more detailed chronology to which I've shown the court already, the 2014, 18, 19 and 21.
Just, I'm sorry, we are necessarily asking you a number of questions as you go along, but this question I think could be answered now.
Yes.
Is it accepted by the Secretary of State that a valid enforcement notice could have been issued against the operational development that was in fact going on in those 4 years? That would have been a valid enforcement action?
Yes.
It is.
If. So the answer is yes, and the qualification is so long as there was a view taken by the relevant decision maker that was the principal form of development that was taking place. That there was a breach, and that the nature of that breach was an unlawful operational development.
Well, just going back, they were alerted in January 14 by a complaint reporting the construction of the Goose House.
Yes.
And that, on the face of it, you know, stripping everything else away, that was a complaint about a dwelling house being erected on the site.
That no doubt was the nature of the complaint, but on the other hand,
that's operational development against which an enforcement notice could be issued.
As a matter of principle, yes, that is right. But
Within
as I say,
within the statutory scheme.
Within the statutory scheme, that's right, subject to a view being taken that in fact on the ground, having visited, having reached a view on what's going on in terms of the nature and scale of any material change of use, the nature and scale of any building works going on, that in fact the principal development that's going on here is an operational development, is characterised properly in that way, rather than as something different. But yeah, I don't. That would have been a question of of rationality for the decision.
There's no. I'll put it this way: there's no evidence before the court, is there, to indicate that the council's position was to wait and see whether the dwelling house of which complaint was made in its construction would actually be used as a dwelling house.
That's right, my lord. There's
no suggestion.
There's no such evidence.
Waiting and seeing.
There's no evidence on what the council's motivation, if there was one, was or wasn't in terms of the time that it took to enforce.
Right.
Now, at 162 of this document, we see what the council was saying about the Ground D appeal, and in particular, at 7.3, the council's case that the inspector ends up accepting, this is 162, para 7.3, is that the council has correctly expressed the true nature of the breach of planning control as a material change of use, facilitated by closely associated operational developments, including the dwelling house and other structures. And that, as I say, is something about which the inspector says makes several findings that I'll take the court to shortly. The respondent's case on ground, first on ground B, which is to do with the idea that the breach has not actually occurred, is in this bundle, supplementary bundle, tab 7, page 62. That is the wrong page. Hang on, I think it's page 64.
64.
Sorry, page 64. Page 64 is headed applicant's case, and the applicant turned first to ground B, which is to say that the breach hadn't occurred as a matter of fact. And at 9.2, the case being made there was that the site is not in a single use. There are 3, it was said, distinguishable planning units on site, and it's set out in a plan what the location and extent of these is. There were 3 units, it was said, a residential area, a commercial area, and a public right-of-way and ancient woodland area as well. 9.3 alleges that there was no pre-existing agricultural use on site, and so to that extent there was an error in the way that the original enforcement notice had been formulated. 9.4 acknowledged that the goose house is used as a single dwelling house along with a small area of clearly defined garden on the site immediately adjacent to the dwelling. So that was the nature of the Ground B appeal, which is to say, yes, there's a material change of use, if you like, so far as the goose house is concerned, but only in respect of that bit of land that immediately kind of abounds the goose house, not the wider area to which I've taken the call. And the supposed division between uses is illustrated in this document at page 44, bundle page 44.
Sorry, the supplementary bundle 44.
Exactly, yeah. Page 44, same tab, same document.
Yeah.
Where the appellant's planning consultant drew what was said to be the putative different planning units that were in play on the site.
Why are we interested in points that were taken that didn't get anywhere?
Well, because the inspector rejected this evidence,
Right.
found in the end that there was a material change of use that covered the entirety of the site, and that was the context for his finding as to what the breach of planning control in this case actually was as a whole. So that's to make sense of those findings that I'm showing the court what that plan is. Their case on Ground D was set out from page 66.
66.
A bundle, page 66,
yes.
Same document. It was accepted that the material change of use to residential was unlawful, but the claim was that the operational development associated with the goose house was immune because of the 4-year points that the court's already well aware of. That's where this case is developed. Now, this evidence was tested at inquiry in November of 2022. The inspector conducted a formal site visit on the 16th of December of 2022. The closing submissions of both parties are within the supplementary bundle. On the council's case, just to pick up on something that was alluded to by my Lord Justice Coulson, the council's closings are at tab 14 of the supplementary bundle. And in the context of the Ground A appeal, which was an appeal about whether or not planning permission should be granted for the development on the site, the council made a submission at page 118 of the bundle. That the change of use, as at 45, amounts to something that they referred to as intentional unauthorised development, which they put forward as a material consideration in the planning balance. And it's recorded from 45B, towards the bottom of this page, some of the questions and answers that were put to the respondent in cross-examination, in particular over the page at 119, at Roman 2, when it was put to him that development of the Peel Site 1 and D2 were entirely intentional breaches of planning control. His first response was, "Is that illegal?" And at 4, he said that he employed experts to tell him if he needed permission. And when asked what the experts told him about that question, he said he couldn't remember. So that was the way it was put. It wasn't put as in the Welland Hatfield way, as a concealment, as a deliberate concealment. The Ground B appeal was addressed from page 120 of this document, and that was where the council set out its case that in fact there was a single planning unit all in the same use as a dwelling house. That's made clear, for example, on page 121 at B Roman 2. This suggests the wider land was associated with the dwelling, not the business as is now claimed. That was their case. And the ground D position was summarised in the council's closings at page 125. At 56, it's noted to be common ground in accordance with established case law, which was Murfitt and Kestrel Hydro. The 10-year rule encompasses operational development that's part and parcel of a material change of use or is otherwise integral to it, and it was common ground matter for your, i.e. the inspector's planning judgment whether the goose house is part and parcel or integral to the material change of use. Then at 57 went on to explain the council's take on that side of it, and of course the respondents' closings are also in the bundle. Those are at tab 13 and set out the opposite side of that debate. Now, the decision letter, which the court has already seen, I understand from my lord's earlier comments, it's in the core bundle, it's at tab 26. I'm going to go into it in a little bit more detail later, but just to touch on it now.
Right. I mean, you're going to come to it twice in your submissions.
Just very briefly to come to it now, to set the context, to see so we can see what the inspector does.
Right.
The ground D appeal in particular is dealt with from page 251. Appeal A, grounds D and F on page 251 of the core bundle, and it's these passages in particular from paragraphs 50 to 21 which are critical for the matters before the court. The court has read these paragraphs already, but
yes.
Just to note very briefly the series of references to most of the relevant cases, including this court's judgment in Kestrel Hydro at 16, at 17, and in particular at 18 and 19 are the critical findings on which I rely. At 18, the inspector's judgment that in the circumstances the operational development and the making of the material change of use should not be viewed as entirely separate developments. A few lines down, the construction of the goose house was clearly for the purposes of making a material change of use of the land to residential. It was integral to it, was in part and parcel of that change. The operational development comprised in the erection of the dwelling, a modest single-storey dwelling, not of a nature and scale that would take it beyond what could be considered to be integral to the material change of use. I consider that in the particular circumstances of this case, that the principal form of development was the making of the material change of use of the land, and that the construction of the building can reasonably be regarded as associated works. Come back to make submissions on that later, but that's the critical exercise of judgment that I say was open to the inspector on the facts of this case.
First sentence of 19.
Yeah, in particular the first sentence of 19 and the last sentence of 18 as well. They go together.
All right.
So,
You call that the critical exercise of judgment?
I do.
Right.
Turning third then, third out of six of my key headings is the key statutory provisions.
Yes.
The statutory provisions, many of which I understand, of course, are very familiar to this court already, but they're at tab 1 of the authorities bundle.
Yes, I've actually taken them out of the encyclopedia.
Yes, no, of course.
So if you just give us, obviously,
Take them slightly out of order. Yes, I'll give section numbers obviously as well as page numbers if any of the court is using the bundle references.
Okay.
So to start at section 57,
Yeah.
which is where all of this begins, really. Section 57, which is on page 7, so I should have said at the bundle. 57.1, subject to a number of provisions, planning permission is required for the carrying out of any development on land. Obviously, that's the fundamental premise of this Act and all of the Acts since 1947. That's the starting point. Section 55, which begins on page 3 of the bundle, defines development in subsection 1, so as to include the carrying out of building engineering, mining or other operations in, over or under land, or the making of any material change of use in the use of any buildings or other land. And there are from 55 to a number of exclusions from that definition of development, but which are not relevant to the case before the court, but they are there, and sometimes this can be important. That's the starting point. The next step is to turn to the enforcement chapter of the Act, and in particular to bundle page 12 at section 171 capital A.
Yeah. Yeah.
Which sets out various expressions used in connection with enforcement, and tells us at subsection 1 that for the purposes of this Act, little a, carrying out development without the required planning permission, or something else that's not material for the case before the court, failing to comply with the condition, etc., constitutes a breach of planning control. When we see the term breach of planning control later, that's what it can mean. Section 172, which is on page 16 of the bundle. Subsection 1, this is the issue of an enforcement notice. Subsection 1, the local planning authority may issue a notice, in this Act referred to as an enforcement notice, where it appears to them, A, that there's been a breach of planning control, see the definition in 171 capital A, and that it is expedient to issue the notice having regard to the provisions of the development plan and other material considerations. So just pausing there briefly, the foundation of the enforcement process is the local planning authority reaching the view required at 172.1 that it appears to them that there has been a breach of planning control, quote unquote, within the meaning of the definition that I've shown the court in 171 capital A. And by doing that, they are also reaching a view, necessarily, because of the way that definition works, on what the relevant development, as defined, which required planning permission but didn't have it, actually is. That's all wrapped into the meaning of breach of planning control, which is contingent on the definition of development in the Act. What is the nature of the development? How best is it to be described? Into what subcategory of the definition in section 55.1 does it fall? All of that, the local planning authority have to consider as to what it appears to them to be the breach of planning control at 172.1a of the Act. That is, in a sense, the originating view on this question. The rest of the steps in the enforcement regime that I'll show the court flow from how that question is answered.
Well, that may be a matter of debate, won't it?
A matter of, I'm sorry?
Debate.
It may be.
172, you're saying is, well, that's subjective. It's entirely up to the council.
Not entirely, no. They have to reach a view that accords with the statutory definitions and that's rational. But it is in the end a question for their judgment, of course, for their evaluative assessment, in as much as there's not necessarily a single right or wrong answer to this question. It is a matter of debate, of judgment, and it may well vary on different sorts of sites, different sorts of buildings or uses or whatever.
Yeah.
But yes, in any event, it all starts here, in as much as you can't do anything else until you've decided there is a breach. And by deciding there's a breach, you've got to decide, well, what is the breach? What is the nature of that breach? What development do we think has given rise to the breach? That all starts at 172.1a. Having formed that view, assuming that they decide that it's expedient to issue an enforcement notice, we turn to 173, which is on page 18 of the bundle. Which tells us what that notice is to include. And 1731A tells us straight away that the enforcement notice has to tell us what the answer to that question at 172 is. So it has to, the enforcement notice has to state first the matters which appear to the local planning authority to constitute the breach of planning control. Breach of planning control, as I've said already, as defined in 171A. And into what category the breach falls. At 3, so subsection 3, an enforcement notice shall, so mandatory, specify steps which the authority require to be taken, or the activities which the authority require to cease. And those steps are in order to achieve, wholly or partly, any of the following purposes. And the purposes are set out in subsection 4. Those purposes include A, remedying the breach by making any development comply with the terms of any planning permission which have been granted, comma, by discontinuing any use of land, or by restoring the land to its condition before the breach took place, or indeed B, by remedying an injury to amenity which has been caused by the breach. Those are the purposes to which the steps can be targeted. And at 5, subsection 5, the enforcement notice may, for example, so non-exhaustive, but may require the things that are at A to D. First is the alteration or removal of any buildings or works, and at C, it's any activity on land is not to be carried out except to the extent specified in the notice. So those are some of the examples of steps that may be set out in the notice. Now, pausing there again, not to sort of overlabour this, but this structure all depends on what matters appear in the first place to the local planning authority to actually constitute the relevant breach of planning control, on which, as I've indicated already, I accept that there may be cases where reasonable authorities could rationally decide one thing or another, but what matters is what it appears to the local planning authority, because that's the way that the statute is framed, to constitute the breach of planning control. The structure of the legislation requires an initiating evaluative judgment, and the statute makes absolutely clear whose job that is. It's the local planning authority, on what it appears to them the breach of planning control actually is, i.e. of what the relevant development without planning permission comprises. The rest of the process depends on and flows from that originating view, because it's only once you've decided what that breach is, if you like, what the development actually is, that you can rationally decide what steps are required in order to remedy it, or to meet whatever purposes are thought to be necessary, either in whole, as it says, or in part. All of that flows from an identification of what you think the breach actually is. And so in so doing, this legal structure requires the authority to make not just one, but a sequence of interrelated planning judgments on a number of different questions. And those questions include, and this is not intended to be an exhaustive list, but those questions include, has there been a breach of planning control? What matters constitute the breach? What is the nature of the breach? If there is a breach, is it expedient to enforce against the breach? If so, what purposes are sought to be accomplished by enforcing, either wholly, as it says, or in part? And we've seen what some of those purposes are at subsection 4. And once we know the purposes sought to be achieved, what steps are required in order to achieve, either in wholly or in part, the purposes that the local planning authority have identified? The statute requires these interrelated judgment calls to be made by a local planning authority, and again, as I've said already, the starting gun is to identify to what actually is the breach of planning control. Now, all of that having been done, assuming that the answer is in the affirmative to issue an enforcement notice, there's obviously a right to appeal against that notice. That's at section 174, which is page 21 of the authorities bundle. 174 1, subsection 1 sets out the right to appeal to the Secretary of State, and subsection 2 sets out the possible 7 grounds on which an appeal can be brought. And just for the court's convenience to sort of look down the list, in this case, the appeal was brought on grounds A, B, D, F, and G. So 5 of the possible 7. Now, I've submitted already that sections 172 and 173 require a judgment to be reached by the council on the correct characterisation of the breach of planning control, if there's a breach of planning control, and I've submitted that requires an exercise of judgment. But there is a safety valve, if you like, if disagreements are taken, if disagreements exist as to how those judgments have been reached. Because if, in the end, the authority's characterisation of the breach is wrong, if the development that needs planning control, or planning permission but hasn't got it, is misidentified, which means that the breach of planning control is misdescribed, then the recipients of an enforcement notice have the safety valve of an appeal under grounds, well, B and or C, either that the matters haven't occurred, or that the matters, if they have occurred, do not constitute a breach of planning control. And of course, in this case, there was an appeal under ground B. Further, it's not a provision that's in the bundle, I don't think, but we can print it if my lord's got the planning encyclopedia, won't need it. Under section 176, not in the bundle, but just for the information of the court, the planning inspectors can vary the terms of an enforcement notice so long as no injustice will be caused to either party. It depends on the facts of the case. It's possible for these notices to be varied by the inspector themselves, as indeed happened in this case, as we'll see. There was a reference to agricultural use that was taken out of the final enforcement notice on appeal because there was no injustice to either party.
Let me make a note of that. That's relevant to something else that I'm considering.
Yes,
not in this case. So,
oh, right.
An enforcement notice can be varied by the local authority.
It can be varied. I'm sorry, my lord. It can be varied on appeal by the planning inspector, so long as the inspector takes the view that no injustice would arise to either party as a consequence.
Right. So it can be varied, but not by the local authority, but by on appeal. Don't worry, I'll look at
perhaps my learned friend might best be placed
to
answer.
don't worry, it's a completely...
Not at all, my lord.
This is a complete bonus ball for me.
I mean, I think the position is that the authority can vary.
Yeah, that's what my learned friend understands as well.
Otherwise they're simply locked into what may be in a minor way an infelicity or inaccuracy in the
expressed.
No dissent from
otherwise
us
they'd
on
have to
that.
go back to the beginning and issue another enforcement notice,
Exactly.
and then there might arise the whole question of time limits.
Yes.
So one can see why, from a legal and pragmatic point of view, it would be sensible for them to have that power.
Certainly no dissent from that to that proposition. So obviously, ground D in particular is given rise to the focus of these proceedings. The court will see what D says. It's the ground about that there being no enforcement at the date when the notice was issued. No enforcement action could be taken. ... Which leads us to 171 capital B. Now those provisions are on page 14 of the authorities bundle. Yeah. These provisions at 171B were inserted into the Act, the 1990 Act in 1992. As we can see at the top of page 15, by the Planning and Compensation Act. 1991. Originally, the 1947 Act had a four-year period, if you like, across the board, regardless of the sort of development that was being enforced against. But since 1992, these amendments set out different time limits within which enforcement action must be taken, depending on what the nature of the breach of planning control is. So at subsection 1, there's a 4-year limit after substantial completion in relation to enforcing against, among other things, building operations without planning permission. At 2, subsection 2, there's a 4-year limit for a change of use to a building to use as a single dwelling house. Not relevant here, but of course was very much relevant to the analysis of the Supreme Court in the Welland Hatfield case. Subsection 3, in the case of any other breach of planning control, so general other sorts of material change of use, not captured by 2, there is a 10-year rule. Now, just for the information of the court, nothing turns on this for the appeal, but it's just in case of interest. Section 115 of the Levelling Up and Regeneration Act 2023 will, if and when it comes into force, and it hasn't, this section has not come into force at the moment, it will change the 4-year periods in subsection 1 and subsection 2 to 10-year periods.
So it'll all be 10 years.
It'll all be 10 years in England, not Wales, but in England it will be. In the event, if and when that section 115 comes into effect, which obviously it hasn't yet, so it's not relevant to the legality or not of the decision letter, but just for completeness.
Right. Do we have that provision?
We've not put it in yet because but we have got copies of it. If just for completeness,
I
if the court
think
would
that
like
would
it.
be helpful to have.
Yeah,
Got
you
it.
guys.
Just think through what the implications would have been
Yes,
in the
of course.
present case.
Thank you.
Had that been enforced, it won't have retrospective effect.
No, of course it won't have that can be handed up. Thank you so much to the court. Won't have retrospect. I'll just let the court receive that and then just show the court what I'm talking about.
Thank you so much. Thank you. So this is the Levelling Up and Regeneration Act.
Yes, which obviously has received royal assent, but many of its provisions have not yet come into force. And one of the provisions that has not yet come into force is on the second page of the 2-page clip, which is section 115, and the court can see what's happening in subsection 1 and subsection 2 there.
Do we have any idea of the timescale for this coming into
I
effect?
don't have any instructions, but I'm very happy to try and get some over the lunch break, for example, if any are forthcoming. It may be difficult, but I'm happy to ask the question to my instructing solicitor and see if we can get any indications for the court.
Yeah. I'm just trying to think through. Perhaps it's an idle exercise to think through what the implications would have been in the present case.
Well, it may or may not have implications, obviously, for future cases. I've offered it to the court really just for context, because we've gone right. Oh, I've gone sought to go right back to the beginning.
It's the right thing to do.
Yes.
To mention it. Thank you very much.
Not at all.
We'll put that to one side.
Yes,
for now.
I'll ask the question over lunch anyway, and if there's any updates on it for the court, I will
Yes, no, that
give them.
would help us. Thank you.
Now, on 171B as it is at the moment, obviously these time periods can play an important role in the fact patterns of the cases of the post-1992 cases, particularly in the event of a statutory appeal underground D.
Yeah.
But the role and importance of 171B in this statutory scheme should not be overstated either. It sets out time limits for bringing enforcement action. The effect of 171B is that once you have identified a breach, see my previous submissions on what that involves, it may or may not be too late to do anything about it. Those time limits have no bearing on the logically prior originating judgment required of the authority in sections 172 and 3 that I've already been over. In particular, has there been a breach? If so, what is it? What is its nature, etc.?
Well, that's why I said there may be a debate about that.
Yes.
Because section 171B, I think you'd accept, is drafted in a very different way. That is objective,
Object.
where there has been a breach of planning control.
Yes.
That's not a subjective in the opinion of the local authority.
That's
It
true.
is where there has been a breach of planning control.
That's quite right, my lord. On the other hand, the establishment of whether there has been a breach of planning control can't be by any. I mean, I appreciate it doesn't say here in the opinion of the LPA, but there's no other. I mean, the planning inspectors obviously, but it's between local planning authorities and inspectors on appeal. There's no other way of. There's no other body who could be charged with.
Well,
with
ultimately,
answering that.
there's us.
Well, of
I mean,
course.
it's a strictly objective
Yes.
test.
I don't accept that the existence or not of a particular kind of breach of planning control is a strictly objective test for the court. I do in the end accept, of course, that the LPA or the inspector on appeal has to operate within the legal limits that I'm working through at the moment. Of course they do, and they have to reach rational judgments and apply the correct statutory definitions of all these different things. Of course I accept all of that. But in the end, decisions on the nature of the breach, whatever it be, will invariably involve questions of degree and matters of judgment. And those questions of degree and matters of judgment are, as I've just said, they are logically anterior to the question about, well, can we do anything about it? They've got to be, because by the time we get to 171B, we've got a breach. We know what sort of breach it is. The question then is, well, how many years have we got to do something about it? Now, an important question, as I say, but to read the judgment below in this case, which I'll obviously come on to, lots about the importance of Murfitt not, quote, overriding the statutory scheme. It's not a direct quote, but the judge says things to that effect. A similar point's made in the Respondent skeleton. We must be careful not to override the statutory scheme, it is said repeatedly. These time limits, yes, they're part of the statutory scheme, an important part, but they are not the fundamental, if you like, part of the statutory scheme, in that they will determine for us whether or not enforcement action can actually be taken against breaches of planning control, an important exercise, obviously, and part of the legal framework. But they don't tell us how to identify what the breach of planning control actually is.
Well, what do you say the purpose of these time limits is?
The purpose is what I've said, which is to identify a breach having been identified, whether or not it is thereafter possible or not, to actually do anything about it, to formulate an enforcement notice.
Well, I think I meant in the wider sense
I see.
of policy underlying the provision. In other words, why have time limits?
We'll have time limits at all because well, some of this goes back, I anticipate, to the Calmworth report that led to these.
But perhaps the answer might be to create certainty.
Yes.
And predictability in
Yes.
the operation of the planning system
I
and
don't dissent
the
from
enforcement provisions in it,
I think that
which is
yes.
of itself a desirable and important end.
I don't dissent from that at all. It's right that one of the, from a policy point of view, a benefit in time limits is to bring along with them certainty that once the relevant time period has elapsed, then whatever the development is, whatever the breach of planning control is no longer capable of being enforced against. But even that begs the anterior question. It begs the question of, well, what is the breach? You know, what actually is the breach? Properly analysed, what is it? And as I say, it may be sometimes that there's only one possible answer to that question. It may be that there's more. As I've said already, very often when you're building a house, just to take that as an example, you're not changing the use of anything. If you're building a house on land which already is in residential use, or if you're extending a house on land which is already in residential use, it's operational development, and that's all it could possibly be. But there are other cases, if you like. There's a Venn diagram, and we're sitting in the centre of the circles, where it is possible rationally to take one view or another as to what the principal form of development in a given case actually is. And we are in such a case. And 171B has nothing to tell us about how that circle is to be squared, how that question is to be resolved. Now,
Right.
Turn next to the fourth of my six headings, which is the authorities. Now, the proviso about them, there are 9 cases in the authorities bundle. The only authority which binds this court is the judgment of my Lord the Senior President, with which Lord Justice Macfarlane agreed in Castrol Hydro, and that is the at tab 10. All of the others are either first instance, which is tabs 2 to 6, I think inclusive, and tab 9, or in the case of Welwyn Hatfield, in the Court of Appeal, and indeed in the Supreme Court. So in the Court of Appeal, the relevant comments on this issue from Lord Justice Richards were over to, and albeit we do have the Supreme Court judgment at tab 8 for completeness, nothing was said, or nothing on my submission, nothing was said that helps us one way or the other, so far as the Murfitt analysis goes, because the case wasn't argued in that way before the Supreme Court. So although there are 9 cases, there's only one binding judgment, and it is a judgment which sets out within it an analysis of most of the relevant first instance authorities too, and indeed it also touches on what was said by Lord Justice Richards in Welwyn, and so there's a bit of a game of diminishing returns by taking the court through all of that material, because it is all summarised in the Kestrel judgment.
Yeah.
So I'm intending, at least in opening, obviously it may be in reply that there's more to say about one or more of these first instance cases, but to say nothing about the first instance cases, because they are touched on, as I've said already, in the by this court in Kestrel. We'll just say something about one of them, though, which is Murfitt itself.
Yeah.
So Murfitt itself is at tab 2.
You do accept, do you, that there is a Murfitt principle?
Oh, absolutely. I accept it. I rely on it.
Yeah. I mean, that's a premise, in a sense, in the whole discussion.
Yes.
We refer to the Murfitt principle, or the principle in Murfitt, as if that's a given. But I suppose one ought just to raise the question, is there?
Yes.
I think both sides here at least agree that there is.
Yes.
You differ as to what it means.
This is a case where we are both purporting to rely on the Murfitt principle as expounded by this court, by my Lord's judgment, as explained there in Kestrel.
Yeah.
We both, as I understand it, purport to rely on it, and we come to different submissions as to how that actually works on the facts of this case. So it's different from Kestrel in that way. So we do, certainly the Secretary of State accepts that the courts have, if you like, recognised, but I'm just going to call it the Murfitt principle, and has recognised this since, at the very least, Murfitt, which is at tab 2, Divisional Court, Lord Justice Waller and Mr Justice Stephen Brown, as he was then. Just to touch on the facts very briefly, all of these cases have interesting but different facts, but just important to understand what the facts were of Murfitt, because of course that takes us in some ways to where we are now. They're set out in the judgment of Mr Justice Stephen Brown, which starts on page 53. We see straight away that there was an enforcement notice in 1977 served on Mr Murfitt by the council, in that case, at East Cambridgeshire, for the use of land, so it's against the use of land for the purposes of parking HGVs. That was what the enforcement notice was about. We see at the bottom of page 53, the last sentence, or penultimate sentence, the appellant started an agricultural plant hire and haulage business in 1959. You see over the page that as part of that business were parked in a farmyard. There were vehicles for plant hire and haulage, were parked in a farmyard that formed part of the site featuring in the appeal. All those vehicles and equipment were originally used in connection with agricultural contract work. That was the original use. By the end of 1963, the farmyard had been extended to include about 15 yards of adjoining agricultural land to the east, and that extension was filled with hardcore, double underline because it's the hardcore that is the relevant operational development in this case, and other things, portable office, and tanks. That happened all before the end of 1963. After 1964, the business continued to expand. Other haulage firms were taken over.
He presumably meant to say, or should have said, 1963. I think.
It may well be, my lord. Yes, that may well be
That's
right.
why the
Hence
sick-
the sick.
sick
Yes,
is,
that may well be. So after 1963 or 1964, the business continued to expand. Other haulage firms were taken over. Apparently, the Appellant was first licensed to operate two 8.5-ton tipper lorries in 1966, and since 1968, the site had been rated as a vehicle park. And by the time you actually get to the enforcement notice, which again is in 1977, the site was used for parking 50 trailers and for the refuelling of lorries operated by the Appellant's transport business. The enforcement notice we see in the following paragraph required the Appellant to cease using the site for parking of HGVs and further required him to restore the land to its condition before the development had taken place, which included obviously the removal of the hard court that had been installed, and that enforcement notice was upheld on an appeal to the Secretary of State. Now, on page 156, at the beginning of the red line passage towards the bottom of page 56, bundle page 56, there's a paragraph that begins on behalf of the Secretary of State, and this is, as I've said already, Simon Brand's submissions as he was then. It asserts that the placing of the hard core is simply part and parcel of, there's that phrase, of the use of this land for the parking of heavy goods vehicles in connection with the haulage business. The Appellant agrees that the only purpose of the hard core was to enable it to be used for the purposes of parking heavy goods vehicles. The Secretary of State submits that it is so much an integral part, there's that word, so we've got part and parcel and integral, to the use of the site for parking of HGVs that it cannot and should not be considered separately, and that when the enforcement notice makes the requirement for discontinuance of the use complained of and requires the restoration of the land, it ought to be understood to refer to the removal of the hard core and properly includes that as a requirement. That was the Secretary of State's submission. Again, to cut a long story short, that's where these terms, it was subsequently at first instance held that those terms constitute, if you like, the ratio of this divisional court decision. That was picked out as being what the core ratio was, and in the end, this is then given a more detailed treatment by my Lord the Senior President when we get to Kestrel Hydro, to which I will come shortly. But do note, again at page 57, there's a reference in the first full paragraph on 57 to the 1971 Act that requires that an enforcement notice shall specify the matters alleged to constitute a breach of planning control and the steps required by the authority to be taken to remedy the breach, steps for restoring the land to its condition before the development took place. Obviously different section, but the same sort of thing, and equivalent provisions to those that exist now in section 173 of the 1990 Act. This is of course a mandatory duty placed on a local planning authority, and it would, the court thought, make a nonsense of planning control if it were to be considered in the instant case that an enforcement notice requiring discontinuance of the use of the site in question for the parking of HGVs should not also require the restoration of the land as a physical matter to its previous condition, that requirement of necessity being the removal of hard core. Lord Justice Waller agreed and added a word or two out of respect to the arguments, and in particular the paragraph where Lord Justice Waller draws it together is the final full paragraph of his judgment, which page 58 of the bundle, where he says, and this is a difficult one because its subsequent cases have commented, including my Lord the Senior President, that perhaps the transcription of this paragraph is not fully accurate, and it has also been described as Delphic. But in any event, it said, if one wishes to see some logic in the distinction between the two types of breach, that's a breach where the variations existed for 4 years or more, and a breach where that which is described as a variation is something ancillary, so there's that word ancillary that my Lord the Senior President's mentioned already to be used. As it seems to me, the former case is one where something is done that on the whole would be obvious, but on the whole would be permanent by the mere fact it's been done, and therefore something that should be dealt with within a period of 4 years, whereas in the second case, where it's in square brackets, a question of an ancillary purpose, the planning matter, might leave land, as in this case, in a useless condition for any purpose. And therefore it's logical that when the use that has no planning permission is enforced against, the land should be restored to the condition in which it was before that use started. I'll rely perhaps on Kestrel in a moment for a slightly, and this is not a criticism of the judge, obviously, but a clearer, in the sense that properly transcribed, appreciations to what those terms mean. But anyway,
these were extempore judgments.
Yes.
We should remember. Given
Exactly.
on the day of the hearing.
Yes.
The other cases, I'm not sure that any of them
I
were.
think most of them are not extempore judgments, but this one...
I think SOMAC may have been.
So that may have been. So again, I was proposing, at least for now, happy to answer any particular questions, but proposing to pass over the various first instance decisions where the courts, where the High Court and indeed deputies in the High Court grapple with Murfitt and try and apply it to different sets of facts. In Welland Hatfield, in this court,
Yeah.
that is at tab 7.
Yes.
We see these facts may well be very familiar to the court. We've touched on it already, but just as a reminder, the head note tells us tab 7. Mr. Beasley obtained planning permission to build a hay barn to be used to store agricultural products. He constructed instead a building that was disguised as a hay barn but was fitted out internally as a dwelling, and he used it as a dwelling, having lived in it for 4 years undetected. He sought a certificate of lawfulness, relying on the 171(b)(2) period of 4 years, which is change of use to a residential dwelling house, and that certificate was refused, and thus began a sequence that ended up in the Supreme Court. The High Court's decision of Mr. Justice Collins quashed the inspector's decision letter on the basis that because the building had never been used for agricultural storage, there was no change of use of the building to a residential, and so for those reasons the statutory 4-year time period did not apply. That was overturned in the Court of Appeal on the basis that there had been, so the Court of Appeal thought, a material change of use, i.e. from the permitted use of agricultural use to residential use. And obviously, as this court is aware, an appeal against this judgment was itself upheld in the Supreme Court, and we've got that judgment at tab 8.
Yeah.
In this court, the lead judgment was given by Lord Justice Richards, albeit Lord Justice Pill agreed and added some comments of his own from page 99 of the authorities. At paragraph 13 of the judgment of Lord Justice Richards, which starts on page 91 of the bundle, Lord Justice Richards summarises their submissions that were made by Mr. Beglan, who was the counsel for the council, for the local planning authority, including a few lines down at Roman 3, a point that hadn't been taken before, i.e. hadn't been taken in the High Court, a point that it would be open to the council to enforce against the use of the building on the ground that it constitutes a material change of use of the land, subject to a 10-year limitation under 171(b)(3). The council's argument based on material change of use of the land is a new one. At paragraph 29, which is on, let's see, starts at the bottom of page 95. It said that the builder do not accept the council's submissions. The building in question was permitted to be used only for agricultural storage in those circumstances. As it seemed to me, its use as a single dwelling house, this is obviously the top of page 96, its use as a single dwelling house is properly to be regarded for the purposes of 171(b)(2 as constituting a change of use in breach of planning control. So it's for these reasons at 29 and 30 that the appeal succeeded in this court, and this constitutes the ratio of the decision of the court.
Where do you say the ratio is exactly?
It is if you second, so A on page 96.
Yeah.
A sort of the first sentence. The use as a single dwelling house is properly to be regarded for the purposes of section 171(b)(2 as constituting a change of use in the breach of planning control. That's what the court was being asked to consider, and that is what it decided.
Yeah.
At 31...
well, 30 is...
I'm sorry.
30 is of relevance, I think.
30 is, I'm sorry, relevant.
30 is of relevance. Obviously,
Yes.
it's dealing because that was the facts of the case.
Yes.
The 171B2 point.
Exactly.
But it does say the plain legislative intention is that once the 4-year time limit is found to apply, it displaces the 10-year time limit.
Yes.
And that, I think, is the respondent's case here, albeit that it's talking about 171B1.
Yes, but of course here there was a finding here that the 4-year limit applied, all of which is contingent on what the nature of the development actually is. And as I say, all the way through up until a belated submission at the Court of Appeal stage, there was no suggestion that the 171B3 point arose as a consequence of there being a change of use rather than an operational development. It doesn't really match the facts of
The
this
sentence
case.
that starts the plain legislative intent. Do you agree?
Yes.
Do you agree with that?
I do, but again, it begs the question: once the 4-year, and that's not a criticism of the judgment, once the 4-year limit is found to apply, then the 4-year limit applies.
But that it displaces the 10 years,
Yes.
even if the situation could be analysed by another route.
Yes. But again, as I say, all of that depends on a finding that the 4-year limit is found to apply, which certainly in our case, in the Caldwell case, has not happened, and indeed the contrary has happened. So that's where the facts in these two decisions don't marry up.
Well, you're analysing by another route, aren't you? According to your argument, you are analysing by another route.
Oh, sorry, is it,
I'm just using the words that Lord Justice Richards did in paragraph 30, which my Lord has highlighted.
No, I don't. I don't say, because even if the situation could be analysed by another route, which is to say that there's more than one way of that the breach has been characterised.
Yes, well, you were submitting that. I thought you were submitting that it was effectively a Wednesbury.
Yes.
A Wednesbury not unreasonable.
Yes.
Not Wednesbury unreasonable view to be taken.
That's right.
There was another analysis here.
Yes.
Which was that the 10-year rule applied.
Yes.
Not the 4-year.
Sorry.
So I was simply adopting the language of Lord Justice
I'm sorry,
Richards.
my lord. That is right, but the difference is I am analysing by another route. But I'm analysing by another route in circumstances where the 4-year limit has not been found to apply. So it's the difference here, and it's an important, critical, logical distinction, is that on the facts before us, the inspector and the local planning authority, but ultimately the inspector whose decision's under challenge before this court, found that the 10-year limit applied.
Yeah,
The problem with all that is it all depends. It would be the easiest thing in the world. The planning authority, in a case where you've got a building on a site, to say, well, we're going to treat this as a change of use, and that thereby escape the 4-year time limit. That can't possibly be right.
But that the reason that I'd say that is right is because their view, although it's the originating view, is not the final view of this matter. Their view is subject first to the review of a planning inspector as part of an appeal. So as I've said already, there's the safety valve of a particular ground B appeal if they've got it wrong. And so there's a.
Well, how can they say that they've got it wrong if it's a matter of evaluative judgment
because,
subject only to Wednesbury?
No, because that's not the case before a planning inspector. Planning inspector's not bound by. The planning inspector comes to the matter completely fresh with fresh eyes and is entitled to undertake a de novo merits review of the decision. The planning inspector's not undertaking a Wednesbury analysis, so they've got a full second crack at it as the recipients of an enforcement notice, if they think that
What is the court to do?
The court,
when it looks at the facts, as you've invited us to do, and it on the face of the facts, there was a building, and it was a dwelling, and it was constructed when it was, no dispute about any of that. And the court takes the view that on that basis, the 4-year rule clearly did apply.
what the court would thereby be doing would effectively be saying that the inspector's decision on this issue, 18 and 19, was irrational.
Well, does it? I mean, that is one argument, and that is the respondent's notice argument, actually.
Yeah, that is the case exactly that's being put.
So it's open to us to decide the case on that basis.
It is.
That was the path we took. But the court can also apply apply. Well, it has two routes. One is the rationality route, and the other is that it was wrong as a matter of law.
But no doubt it does have those routes open to it, but it could only be wrong as a matter of law if the court decides that the breach was fundamentally misdescribed, misunderstood, mischaracterised by the planning inspector. And that's why I've tried to take the court through how that process works in the statutory scheme slowly, because my submission is that step, that originating step, is not, and I do obviously appreciate some of the questions, the targeted questions from my lords and my lady on that push back on this characterisation of it. But my submission is that foundational step does inevitably involve not just, if you like, a sort of black letter objective analysis, but also a series of interrelated and evaluative planning judgments. It may well be, in many cases, that where a building gives rise to a change of use, that decision makers decide that it's the building that's the principal form of development. That may well be right, lots of times. It may well be that you know, say we'll come to Kestrel in a moment, but it may well be that changes of use happen, and the inspector decides that on the facts of this case.
Well, the inspector purports to have applied the so-called Murphy principle.
Yes, he
And
does.
if he misunderstood or misdirected himself as to the true meaning of the Murphy principle, that would be an error of law.
Yes, correct.
And his decision would be bad.
Correct. That is so, and that's the way that it was put by the learned judge below. But we'll come to the inspector's decision letter. But as I have sought to, well, I've mentioned it already, but I'll take the court to it in a bit more detail. The inspector's analysis of that principle could not, on my submission, be bettered, really. He's got a thorough and impeccable understanding of what that principle comprises. He was taken to it in some detail by learned counsel on both sides, and he does an excellent job at explaining what it is. And having decided what it is, having directed himself properly to what it is, which of course is a question of law, raises a question of law that he's got to get right. Having done that, which he does, in my view, in my submission successfully, the application of the Murphy principle to the facts before him was a matter of fact and degree. On Welling, right. Just again very briefly, we left off at 30. At 31, Lord Justice Richards goes on to say, "I wish, however, to say a little more about the case being advanced by the council." And this is touched on by my Lord the Senior President in Kestrel, but just to be absolutely clear about it, everything that runs from "I wish, however, to say" onwards is obiter, responding to a new point that hadn't been developed at first instance.
So 31 and 32 are agreed to be obiter dicta.
Yes, they are.
But I believe that's right.
I believe that's right. Yes. Yes.
So not binding on this court.
Not binding on this court, but obviously that not to say that they can't be persuasive. The court said at 32 towards the bottom on page 96, the final three lines on page 96, "I'd be reluctant in any event to accept that an enforcement notice directed against the use of land could properly require removal of a building that enjoys an immunity from enforcement by virtue of 171B1. But it's unnecessary for me to say anything more on the point. ... Now, as I've said, in the end, that was obiter responding to a late-ish submission. But we know from some of the first instance cases.
But do you say? Sorry to interrupt you. Forgive me for that.
Not at all.
I just want to be clear. Do you say that he was wrong?
Yes, because we know from many of the cases, and indeed from Kestrel, that there is no magic in the Murphy principle allowing the removal of buildings as opposed to other kinds of operational development, including buildings that would, taken on their own, have enjoyed immunity from enforcement. So it's not obviously a criticism of this of Lord Justice Richards, because he was dealing overture with, you know, and relatively briefly with something that hadn't been properly developed to him. But we know from Kestrel, that we'll come to in a moment, that there's certainly no in principle problem with Murfitt applying to buildings, and buildings that would, if taken on their own terms, have enjoyed immunity from enforcement under 171B1. Everything depends, in any case, on what it appears to the authority to constitute the relevant breach of planning control. And if the breach appears to that authority to be a material change of use, then what steps are required to achieve the relevant statutory purposes, including the removal of buildings, which are integral to that change of use.
The Murfitt principle has existed for more than 40 years.
That's right.
In the course of that time, has it ever been deployed, as it is being in this case, to justify the effective immunity from enforcement, the reach of the statutory scheme beyond immunity for enforcement under the 4-year rule in circumstances such as these? In other words, the removal of a dwelling house which has been erected more than 4 years ago, substantially completed more than 4 years ago, in similar circumstances to this case. Is there any case that you can point to where there is a parallel application or purported application of the Murphy?
I don't understand there to be a parallel case to this on the facts that points in one direction or another. I don't think there is one. So I think.
Well, has your argument ever been put forward before?
Well, I'm not. I don't know. We've not found such an example.
No, I'm assuming you haven't.
I'm certainly assuming. Obviously, if we had done, we would have put it before the court. Yeah. So I suppose the caveat to that is that the differential time limits became a feature of the statutory scheme not in 1947 but in 1992. But nonetheless, that's some time ago, and so the nature of the particular fact pattern, if you like, before this court is not one that the court, so far as I think myself and I think my learned friend is nodding as well, so far as we're aware, it's not a fact pattern that has come before the courts before.
Thank you.
I do say, though, that nothing, if you like, turns on its novelty, in that the courts certainly have many times over the years since Kestrel Hydro been called on to consider buildings. All sorts of buildings, one such case was indeed Kestrel Hydro, which the courts have, which this court has at tab 10.
Mm-hmm.
We're going to that now.
Yes, if that's convenient.
We're not going to Lord Mance's judgment in.
Not at the moment. No. As I say, it is relevant on my submission in that it does talk about. Lord Mance talks about when a material change of use starts. But I was going to touch on that very briefly later.
All right.
The Supreme Court did not develop any analysis one way or the other of the Murfitt line that had been taken in the Court of Appeal. The case was decided on for different reasons. Kestrel Hydro, tab 10, obviously a very familiar territory for my Lord the Senior President who wrote the lead judgment. The facts are summarised from paragraph 3 of the judgment, which is on page 167. We have an enforcement notice, it's paragraph 3 of the judgment, in August 2013, alleged a breach of planning control by the making of a material change of use in premises known as the Kestrel in Staines from a residential use to a mixed use for residential purposes and as a private members club, and the erection of various structures on the site and the laying of hard standing to create a car park, a site that was also in the green belt. At paragraph 4, the notice required that the unauthorised use be ceased and the site be reverted to its lawful residential use and the structures and the hard standing be removed. The enforcement notice was appealed on 4 grounds. The inspector dismissed the appeal on ground D, among others, on the basis that the structures to be removed were part and parcel of the material change of use. A challenge to the inspector's decision failed before Mr Justice Holgate. We've got that judgment at tab 9, and Mr Justice Holgate's judgment was the subject of the appeal before this court. At 5, paragraph 5, the first main issue was whether the council's enforcement action was ultra vires because it sought to attack operational development that had been on the site for more than 4 years. And there was another issue to do with the way that the Grand F appeal was determined. Page 172 of the authorities bundle. Having been through, I should say, in passing, but importantly, the relevant case law from page 169, including Murfitt and several of the other cases that we've got in the bundle, all set out in those paragraphs that lead up to paragraph 14 on page 172. Page 172 sets out the terms of the enforcement notice and its requirements, in particular at paragraph 14 and the various quotations there. Page 173 sets out the inspector's key findings and conclusions on the ground D appeal. See, in particular, if the court could just turn over the page to 174, paragraph 19 of the judgment, there's a reference to what the inspector concluded, and it said that items 1, 3 and 5 to 10 were completed before August of 2009 and would normally be immune, but having regard to Murfitt, Somac and Bowring, the notice can nevertheless require their removal. Items 2 and 4 are not immune anyway. So items 1, 3 and 5 to 10. And just to, if the court's interested in what those items actually were, there's a numbered list, just for, if perhaps it might just be worth very, very briefly turning it up. It's page 139 of the authorities bundle, within the judgment of Mr Justice Holgate, at paragraph 10 of his, paragraph 10 of his judgment, so the paragraph numbers go a bit strange. Page 139 of the bundle, there's a list of what the 10 items, were in total. So the court will remember 1 and 3 and 5 to 10 inclusive were the structures that were being said to, if you like, benefit from. That's the right word. The Murfitt line of cases, that so to be removed included a marquee containing a timber shed, hard standing, covered walkway, 3 more sheds, a wooden building, more sheds, summer house, and a timber building used as a tea room, to give you the court a sense as to what was being discussed there. One qualification, back in the judgment of this court, one point from the authorities that I did just want to note very briefly was the Bowring reference that my lord, the senior president, makes at paragraph 13. I should have just picked up as I was moving through that bit of the judgment. Bowring notes, there was a first instance case, but cited by my lord, the senior president, here at paragraph 13 of this judgment. The point is at the top of page 172. 3 lines down, it will not be sufficient if the works are integral to or part and parcel of the present unauthorised use of land if the works have been undertaken for a different purpose, for a different and lawful use, and could be used for that other lawful use, even if the unauthorised use ceases. Relevant here, in that is a further, if you like, qualification or limitation to the principle in Murfitt, and not one, of course, that on this facts, no. on the facts before this court was relevant. So, my lord, the senior president's consideration of whether the enforcement notice was or was not ultra vires starts at paragraph 20 of the judgment, which is on page 174. The submissions advanced on behalf of the then appellant are summarised at paragraphs 20 and paragraph 21 as well. It was said that there is a clear distinction between operational development and material changes of use. It was said that Murfitt was wrongly decided, and indeed all the lots of the other first instance cases were wrongly decided. 2, because 21, 3 lines down, 4 lines down, Murfitt was alien to the statutory scheme, so it was said. And at 22, there was a submission that any legitimate concern about the survival of useless buildings was met by the ability to issue a discontinuance order under the Town and Country Planning Act, which is again is something that is said by the respondents in this case too. At 23, the court rejected those submissions. The court found that Murfitt's good law, which represents a lawful application of the statutory scheme, that's a few lines from the bottom of 2023. As in every case of planning enforcement it must be, said the court, to the particular facts and circumstances of the case in hand, which is what happened here. At 24, the court endorsed the submissions of Mr. Guion Lewis for the Secretary of State, that it's necessary in every case to focus on the true nature of the breach of planning control against which the local planning authority has enforced. My Lord considered the matters the enforcement notice must contain, references to section 173 of the Act. So I've taken the court to those provisions already, but they're set out, some of them are referred to here. And the reference right in the final line of page 175 to restoring the land to its condition before the breach took place. Top of the next page, and the provisions for grounds of appeal in 174 are framed in terms of the breach that is constituted by the matters stated in the notice. Central, it is said, and I put some emphasis, as the court will have appreciated, on that word central. Central to all of these provisions is the concept of the matters that constitute the breach. And I rely on that analysis to support the submission I've already made on the statutory scheme. But the focus the court refers to here on the nature of the breach was absent from the judgment below. And I'll develop that when I get to the judgment shortly. In 25, in Kestrel, the local planning authority were alleging a breach of planning control by making an unauthorised change of use, together with various structures associated with that mixed use and the laying of hard standing, etc. At 26, this was one of those cases in which the change of use offending lawful planning control entailed the carrying out of physical works to enable and facilitate the unauthorised use of land. Though some or all of those works comprised engineering or building operations, this in itself did not, as a matter of fact and degree, take the building and planning control out of the ambit of section 171b3 and into the scope of 171b1. And again, I do put some emphasis on the court's reference there to the idea of it being a matter of fact and degree. I rely on that positively, because in the decision letter, to which we'll come to shortly, that's exactly the way that the inspector took it, as a matter of fact and degree, which invariably, inevitably, then requires someone to actually make a judgment on those matters of fact and degree, informed, among other things, by visiting the site and all the evidence of what the relevant operations and changes of use comprised. It is, in the end, a matter of fact and degree, as this court has confirmed on our submission at 26 of Kestrel. And at 28, the court sets out the principle. And I won't read it all out, but obviously very, very important that the court do, if it hasn't recently, read out 28 to itself. This is the principle. I think both sides purport to rely on this principle. We certainly do. At 29, this was recognised by Mr Justice Stuart Smith and Somack in his observation that the application of the principle, or inverted commas test, in Murfitt must be, and it's the same idea again, a question of fact in each case. This is the first sentence of paragraph 29 of the judgment in Kestrel. Of course, we rely on that formulation, but positively, it's consistent with the formulation at 26 about the matter of fact and degree. Like with many areas of planning law, this is one where the court's role, if you like, informed by the statute, is to set the parameters within which the applications of judgment must happen, must operate. But in the end, there are judgments as a matter of fact and degree, it's a question of fact in each case to be reached, and there are no universal answers that are going to apply to every single case across the board. It depends. It depends on the particular circumstances of each case, and that's what the court in our submission is recognising at 29. At 30, the court refers again to this idea in the third line of 30 to nature and scale. It does not embrace operational development of a nature and scale beyond which is truly integral to material change of use. It seems clear that this is what Lord Justice Waller had in mind when he used the word ancillary. So again, my Lord, the Senior President, mentioned earlier on in one question to me, ancillary, you know, I'd said integral and part and parcel as a summary of what the Murphy principle comprises, and my Lord, the Senior President, said, well, there's ancillary too, which is of course right. But on my submission of what ancillary is doing, if you like, as part of the Murphy principle, all it's really doing is another way of saying the same thing, which is that your nature and scale, the nature and scale of the operational development, can't exceed that which is integral to the material change of use, which is of course that's what the word integral is doing. Anyway, so they are in effect, in the way that they're being used in this line of case law, these two words are synonymous. The key though is the nature and scale. That's the third line of paragraph 30. The nature and scale. Who is to decide? Rhetorical question. Whether the nature and scale does or does not exceed that which is truly integral to material change of use. It must be the primary decision maker, local planning authority in the first instance, and then the inspector on appeal. There's no way of a High Court judge, theoretically, being able to insert their own, subject of course to normal public law principles of rationality and all the rest of it. There's no way of a High Court judge, if you like, substituting their own view on nature and scale. It's a quintessential exercise of planning judgment of the sort that planning inspectors make every day. To take a step back, the courts, and in particular this court, in Kestrel, have recognised the following layers of planning judgment to be exercised as a matter of fact and degree in cases of this sort. There are more, but if I give the court just a list of 7.
If you could take these reasonably sedately.
Yes, of course, my lord, of course. If I go too fast, you see, the court will slow me down.
Ask you to pause a little.
No, of course. So there are the following layers of planning judgment to be exercised. All give rise to questions of matters of fact and degree. In cases of this sort, and by cases of this sort, I mean the sort of cases in the Murphy line, which we are in.
Yeah.
The first is the nature of the breach of the planning control.
Yeah.
The second is that the matters said to constitute that breach. The third are the purposes sought to be accomplished by enforcing against that breach. The fourth, the steps required in order to achieve those purposes, wholly or partly, including restoring land to its previous condition. The fifth, if the breach is an unlawful material change of use of land, what operational development, if any, is associated with that material change of use of land? The sixth, if that operational development would otherwise be immune from enforcement on its own, is it of a nature and scale to be integral to or part and parcel of the material change of use?
Sorry, I just missed the last bit.
I'm
Is
sorry.
it of a nature and scale?
So as to be integral to or part and parcel of the material change of use. And seventh, if so, if it would be of a nature and scale to be integral to or part and parcel of the material change of use, if so, whether its removal is necessary to fulfil the relevant statutory purpose or purposes in whole or in part.
To fulfil the statutory purposes.
Yes, by those I mean the statutory purposes at 173, 1734.
1733 and 4.
1734 in particular, which sets out the purposes. 3 sets out the steps, and 4 sets out the purposes. Yes.
Okay.
On all of those matters, and no doubt there are other ways that those could have been formulated, and more of them. But on all of those matters, at the very least, judgments are required. So in light of those authorities, certainly before lunch, then it might be just a little bit more to do after lunch. I'm focusing on briefly as I can, the judgment below and why I'd say it was wrong. But I'm hoping before lunch to be able to make submissions on the decision letter. And,
yes.
And why, this is the fifth of my six
Right.
topics, which is brief submissions on the decision letter itself and why it represents a lawful understanding of and application of the principles that the authorities describe.
Right.
So the decision letter itself is at tab 26 of the core bundle, so it's core bundle tab 26. We've been there once briefly. We are, it starts on paginated page 247 of the bundle. It covers in the head note appeals A and then B and then over the page C. We are, just for the avoidance of any doubt, concerned with appeal A, which is the enforcement appeal in relation to the, if you like, the Goose House area, which relates to the plan that I've shown the court. At page 249, the inspector turns to consider first the ground B appeal on page 249 from paragraph 8, which was, as the court will recall, it's the allegation that the alleged breach had not occurred as a matter of fact for all the reasons summarised at paragraph 9 in particular of the decision letter. At 12, the court will see a few lines from 5 lines from the bottom of 12 and the sentence starting overall. The inspector was satisfied that the entire site was used for residential purposes associated with the use of the Goose House as a dwelling house. And so, at 14, at the top of page 251, the conclusion was, at 14, as a matter of fact and degree, ... the matter stated 4 lines down, the change of use of land to residential use as opposed to mixed use has occurred as a matter of fact. And so the appeal on ground B failed. And then the inspector turns to ground D from paragraph 15. 15, common ground that the material, this is a few lines down, common ground that the material change of use has not occurred for sufficient time, 10 years, to have become immune. It's well established, 10 lines down or so, that where there's been a material change of use of land, structures which may be viewed in isolation have become immune from enforcement may nonetheless be required to be removed in order to restore the land to the condition it was in before the breach of planning control. At 16, both parties refer to Kestrel Hydro as the most recent consideration of the relevant case law, including that in Murfitt, Somac, Bowring, and indeed Welling, both in the Court of Appeal and the Supreme Court. Kestrel Hydro sets out the principle that an enforcement notice directed at a breach of planning control ... may lawfully require the land or building in question to be restored to its condition before that change of use took place by the removal of associated works as well as the cessation of use itself, provided that the works are integral to or part and parcel of the unauthorised use, and are not works previously undertaken for some or other lawful use of land, etc. Kestrel at 17 was concerned with development that was subsequent to the unauthorised material change of use enforced against. In this case, it's argued the operational development comprising the construction of use has preceded the change of use, and that the erection of the dwelling was not merely incidental to, ancillary or supportive of, but rather it was operational development over the page in its own right. That was the argument. While the operational development must undoubtedly be supportive of the change of use, I find nothing in the cases cited to indicate that development must necessarily be capable of being described as ancillary or incidental, having regard to the qualification in Kestrel, the use of the word ancillary in Murphy. It's sufficient that it's part and parcel of and integral to the change of use. Neither is it the case that works carried out before the change of use clearly affected, as appear to have been the case in Somac and Bowring and possibly Murphy, could not be integral to and part and parcel of the change of use.
Now, why is that passage consistent with Murphy? Where does he get the idea that the development well, there's nothing in the case law that suggests that the development must necessarily be capable of being described as ancillary or incidental, and everything in the cases so far is referred to ancillary and incidental development.
It's the understanding of ancillary. The ancillary has it's a particular term of art in one field of planning law. And what the inspector is explaining at 17 is that in this context, ancillary has the meaning that the senior president ascribed to it in the Kestrel judgment, which is to say, essentially, I've taken the court there just now, but is the operational development of a truly of a nature and scale so as to be described as integral to the change of use. That's what ancillary means here. So he understands, the inspector, understands the meaning of these terms. He's been taken to the judgments in detail. He sets out what they mean correctly in my submission in paragraphs 15, 16, 17. And he's making clear what ancillary actually means in this context.
It must be me. But I look at paragraph 16 of this decision letter.
16, yes.
Look at paragraph 16, second half of it.
Yes.
And he rightly says what was decided in these cases is that enforcement notice can lawfully require the land or building to be restored, provided that the works concerned are integral to or part of the unauthorised use and are not previously used for lawful use.
Yes.
It doesn't embrace operational development of a matrix scale, etc. So, provided that they are integral to or part of the unauthorised use.
Yes, yes.
And then in the very following paragraph, he says it's not enough that they should be integral to.
No, he says it is enough. He says it is sufficient that they be part and parcel of and integral to. That's 5 lines from the bottom.
I find nothing in the cases to indicate that the development must necessarily be capable of being described as ancillary or incidental. That's saying precisely the opposite. I'm sorry.
No, he says if the full sentence. Sorry, it may be that I'm not quite. As I say, ancillary in other areas of planning law has a particular meaning, which is to say incidental to.
But I'm sorry, Mr. Simons. If my lady is looking at the top of page 252.
Yes.
And what the inspector says there is that he finds nothing in the cases to indicate that the development must necessarily be capable of being described as ancillary or incidental.
Yes, that is what he says. Yes.
Are you saying that is correct as a statement?
I'm saying that it's correct when read as a whole, because I say when the sentence is read as a whole, because what he goes on to say is that he's having regard, when he says that, to the qualification in Kestrel Hydro of the use of the word ancillary in Murphy. So what he's saying is that, and obviously ancillary is a word that appears in the cases.
Sorry. So how does that sentence work then? Because there's a comma after incidental. Should that be a full stop there?
Sorry.
Because he then goes on to another apparently main clause. It is sufficient that it is part and parcel of.
I don't say.
Does that sentence work grammatically?
As I read read
No, I
it.
think it doesn't. I think it would either be a semicolon or a full stop.
It's maybe the critical sentence in the decision letter. And if it doesn't work grammatically, that may be troubling.
I do say that it is clear when read, as I say, just reading the sentence. Obviously, the court it sounds like the court is not with me on the approach to this sentence, but
Well, no, we're asking you how.
Trying to understand
no,
it.
of course. I say that it's clear what he is attempting to say, and that is that ancillary, in the sense of being incidental, ancillary or incidental, is not the test. The test, having regard to the way that ancillary is used in
Integral.
Murphy. Sorry?
The test is integral, not ancillary or incidental. Is that what he's saying?
Yes, that responds to the first two sentences of paragraph 30 of Kestrel.
Well, then I'm sorry, I still don't see how you can reconcile paragraph 16 and 17. You've got paragraph 16 saying it must be integral,
Yes.
and you've got paragraph 17 saying it mustn't.
No. He says it is sufficient that it be integral. That he says that 5 lines from the bottom of 17. So he's clear that integral is the test, and part and parcel is the test. And what he's saying is that ancillary doesn't add anything to that test, and that is relying on the way that ancillary was approached in Kestrel.
So suggest that
He says it is sufficient that
integral is the test.
and part and parcel of. Yeah,
Well, that's the same thing.
it's the same thing. Yes, exactly.
And ancillary means nothing.
Not that it means,
Doesn't add anything.
Not that it means nothing, but that as he calls it, as having regard to the qualification given in Kestrel on the use of ancillary, it doesn't mean anything that adds to the test of integrity, and that is, in my submission. Obviously, the senior president can reach a view on this, having been the judge who wrote the paragraph. But that is, in my submission, a correct application of understanding of the first two sentences of paragraph 30 of Kestrel, which say that ancillary, when it's used in Murphy, do not embrace operational development of a nature and scale exceeding that which is truly integral to a material change of use.
The struggle I'm having with this sentence at the moment,
Yes, my lord.
it may be just my failure to understand it. It may be staring me in the face what it means. I don't think it works grammatically, does it? Because there has to be a full stop either after the word incidental or after the word Murphy. Because otherwise one's got two main clauses.
It must come after Murphy, I think.
But what does he mean? Does he mean to say must necessarily be capable of being described as ancillary or incidental, having regard to the qualification in Kestrel Hydro of the use
No,
of the word,
I read.
and then full stop after Murphy? Or does he mean full stop after incidental?
My submission is, my submission is that the comma after incidental would better have been a semicolon or perhaps a full stop, because having regard to begins a new clause.
So that would suggest that he's eliding the word ancillary with part and parcel and integral.
Yes, that is that. Yes, exactly. That is the submission that I make on the meaning of this passage. He is eliding those terms. He's saying essentially that they mean in the end the same thing, and he's doing that on the basis of an understanding of paragraph 30 of Kestrel.
Yeah. So he is on your construction of this sentence, splitting it in the way you suggest it should have been split. He is discounting the test or criterion of ancillary-ness or incidental.
He's discounting ancillary, if you like, as a freestanding test that adds something to the other terms. So he's saying that ancillary, in effect, doesn't add anything, because ancillary, as understood in Kestrel, really means something which is part and parcel of and integral to. But these are different ways of approaching the same thing. And that, as I say, I mean that is consistent with, in my submission, what is said at paragraph 30 of Kestrel. At 18, he finds on the facts before him that the operational development and the making of material change of use should not be viewed as entirely separate developments. He notes the evidence that the purpose of erecting the building was to provide a dwelling. The construction of the goose house was clearly for the purposes of making a material change of use of land. It was integral to and part and parcel of that change. The operational development comprised in the erection of the dwelling. A modest single-storey building was not of a nature and scale that would take it beyond what could be considered to be integral to the material change of use. And at 19, I consider in the particular circumstances of this case that the principal form of development was the making of a material change of use of land, and construction of the building can reasonably be regarded as associated works.
I'm afraid I don't follow the last sentence of 18 either.
Of 18.
Because if you take his conclusions to their logical extreme, provided that the dwelling house is part and parcel of the change of use, any dwelling house would be part and parcel of the change of use, and it doesn't matter how big it is. So saying that the operational development was modest and so on, and it wasn't of a nature and scale, is totally meaningless.
My lady, obviously, I don't accept that. The Kestrel judgment, at least once, talks about, and I think it's at paragraph 30 that we've just been discussing, refers to development being of a nature and scale so as to make it integral to or part and parcel of.
Yeah, absolutely, and that makes complete sense if you give ancillary a proper meaning, but it doesn't if you treat it as the whole development.
The submission is that whether or not a particular building work, operational development is of a nature and scale to take it beyond what could be regarded as integral or not is a question of fact. I mean, it must be a question of fact. There's no, if you like, objective answer to that question. It will depend on the building. It will depend on the use. And what the inspector is saying in relation to this building, this unit, this planning unit, and these uses, is that his view is that the principal form of development is not the building, but the change of use. And my submission is that
that's the change of use to residential.
That's right. Yes.
Which
change
requires
of use
a house.
to residential. Sorry.
Of whatever
Which
size.
requires a house.
Which requires a house. That's right. But of course,
If it didn't have the house, it wouldn't be a change of use.
But there's nothing magical about that relationship. If you didn't have the hard standing in Murphy, you can't apart.
There's nothing magical about it.
No.
The only case on it is Well in Hatfield. It's the only case about a dwelling house.
Well, that's so. I mean, there are cases about that's right. It's the only case about a dwelling house.
All the linguistic
but
doings, which I'm not clever enough to understand. All of that slightly takes us away from the real point here, which is this was a house and it was in breach of planning control.
yes.
And as a result of the house, there's a change to residential use. Well, it wouldn't be a change to residential use if there wasn't a house.
That's right, of course. But that is so in lots of the fact patterns where you have, for example, as I was saying in Murphy, you don't have a change of use to an HGV parking area unless you've laid down hard standing to enable that to happen. Very often in these cases, the physical works, whatever they might be, are facilitative of, and indeed necessary to, integral to, the change of use that happens. There's nothing. There's nothing unusual about that. That still depends on a judgment on nature and scale. That may be.
Maybe, Mr. Simon, sorry to interrupt you, but maybe after the short adjournment, you can rack your brain and give me a positive example of a scenario in which a dwelling house would be of a nature and scale that would take it beyond what was considered to be integral to the material change of use from something to residential.
Well,
Don't do it now.
Don't do it now.
I would suggest you don't
Fine.
You don't answer that straight away. You may want to reflect on,
No, of
on the
course.
question.
So the question is a scenario where a building, where
A dwelling
dwelling
house
house.
is of a nature and scale that would take it beyond what could be considered to be integral to a material change of use from non-residential to residential.
Right. Okay.
Okay?
I think although you'd valiantly set off to complete your submissions on
Not
the decision letter before the short adjournment,
quite. Not quite.
we haven't, because of our
No, not
exchanges with you, we haven't quite managed that. So don't worry, we'll come back at 2:05 and you can complete that part of your argument at that stage.
I'm grateful.
Thank you very much. 2:05.